She's there. Can you hear me? Hi. Welcome to the Center for Global Affairs. Most of you know me. I'm Vera Jelinek, the Divisional Dean of the Center. I'm going to make this so super short that I thought I had lost half my notes. And the reason is that Professor Trahan has forewarned me that I give too many details and therefore I should limit my remarks. But I know that you are here to hear these people, this distinguished panel, and not me, but you can't get away without saying something about the center. So while I'm going to be brief, I'm going to tell you that we're celebrating our 10th anniversary. It doesn't mean that Global Affairs has not played a part in the school before that, but 10 years as a center. It's home to a master's program in global affairs, to non-degree continuing education courses year-round, public events like the one tonight, as well as grant-funded events in peace building and in other areas. We have 300 graduate students right now, many of them in this room. Some of them are putting the final touches on their thesis or on their capstones. And on May 17th, I'll be shaking, I guess, close to 100 hands, and they'll be the recipients of their masters. We already have about 1,000 alumni working throughout the world in non-governmental organizations, in government, in the private sector, and elsewhere. So we are building the global leaders that I always promise them we will be doing. International law is an amazing thing for me that has sparked such interest. In my days, which were 100 years ago when I was pursuing graduate studies, it was a much more rarefied field and didn't attract the sort of attention that it does today. It plays a part in many areas within our program. It's a core course in the master's program. It is a focus of field intensives, many of which are led by Professor Trahan. It plays a part in our non-degree programs and has often been the focus of discussion in this room, different aspects, not necessarily Guantanamo. Jennifer Trahan has been I would say, the engine and the guiding spirit that has driven international law and human rights program and made it as successful as it is. She teaches international law. I'm going to go fast, so it'll be short. Human rights theory and practice, international justice, transnational justice, the U.S. use of force, plus more. She's been a consultant to the International Center on Transitional Justice, worked on cases before the Special Court for Sierra Leone, and was counsel to the International Justice Program at Human Rights Watch. She writes, has written 2 books on genocide, is passionate about that, war crimes. She lectures, she mentors, she testifies, and I don't know how she finds that many hours every day. All that just skims the surface. Please join me in welcoming Jennifer Trahan, who will introduce our distinguished panelists.
Thank you, Vera, for that gracious introduction. And thank you to the panelists and to the audience for being here today. You have the panelists' bios, so I will just briefly welcome William K. Lietzau, previously Deputy Secretary, Assistant Secretary of Defense for Rule of Law and Detainee Policy, Professor Sarah Cleveland, now Louis Henkin, Professor of Human and Constitutional Rights at Columbia Law School, formerly Counselor on International Law to the Legal Advisor at the State Department, Ken Roth, Executive Director of Human Rights Watch, and Professor Mary Beth Altier, Assistant Clinical Professor here as well. So as you probably know, the first detainees arrived at the detention facility at Guantanamo Bay in 2002. So we've already passed the 13th anniversary of detentions there. It's estimated that as many as 780 individuals have been held over the years. While we perhaps have lingering images of individuals held in wire mesh cages, the facilities are much improved from the early days, yet detentions do continue. Presently, there are 122 detainees, despite President Obama's 2009 executive order that the facility should be closed in 1 year. So why is closing Guantanamo so difficult? That is the question we will examine today. We will look at this from a variety of perspectives. First, a legal perspective. There are actually complex legal issues undermining detention authority, underwriting the detention authority. Second, there are practical difficulties in terms of remaining transfers. And I will just note, assuming this remains the goal of the executive, because if closing Guantanamo is not accomplished during this executive, we don't know if this will be the goal of the next administration, so we would have to see. Thirdly, we might also want to be cognitive of an additional layer, and that is perception. So we know the adage, justice must be done and be seen to be done, and whether or not we can make a case for part or all of what is occurring at Guantanamo as within U.S. authority, which our panelists may or may not agree with, there certainly is the perception, at least internationally and to some extent domestically, of Guantanamo as a legal black hole, whether one agrees with that characterization or not. Admiral Mike Mullen has called Guantanamo a recruiting symbol for those extremists and jihadists who would fight us. Now, as to the legal precedent, the Geneva Conventions do provide for detentions during the duration of hostilities, at least in the context of international armed conflict. And the U.S. historically has used military commission trials to try law of war violations. These may or may not be clean fits. As in previous wars, we arguably had a lot more clarity of what our battlefield was, who our enemy was, and therefore the duration of hostilities seems perhaps clearer. Here we have broad invocations of armed conflict, namely under the Bush administration that the US was engaged in a global war on terror. Under the Obama administration, that framework was narrowed, but only somewhat, to a war against al-Qaeda and associated entities. Also relevant to our discussion is the 2014 end of combat operations in Afghanistan, which may or may not have implications for continued detention authority, particularly against Taliban detainees. As to practical challenges, it may be helpful to keep in mind the three categories of individuals being held, namely those cleared for release, but still being held for a variety of reasons, those slated for military commission trials, and what some will call indefinite detainees, others will no doubt call law of war detainees. And as Professor Altier will attest, we know that certain percentages of former detainees do re-engage in hostilities, so there may be legitimate concerns of recidivism. So hopefully our panelists can set us straight, given all these competing complexities. So I will ask them a series of questions, at the conclusion of which I will invite audience questions. So hang on, just for, I think I'll switch over. 2 to 4 feet away, so I can get them talking upstage. Sorry. Okay, so I'm gonna, is this on? Okay, I will start with maybe a narrower question that maybe is easier to tackle. So we have a group of individuals at the facility who are either approved for transfer or approved for conditional transfer for a total of 57. Why, panelists, are they still at Guantanamo? And given most are Yemeni in origin, what can be done to transfer them if one doesn't want to transfer them to Yemen, given the current precarious situation there? Who would like to kick us off? Sarah?
Sure, I'll give it a whirl. Can you hear me? Yes. Okay, they weren't sure this would work. First of all, I would just start out by saying there are basically three big questions with respect to Guantanamo closure. What do you do with the Yemenis? What do you do with the long-term law of war detainees? And do you bring the people to the United States to close Guantanamo, and does that actually close it? And these are the questions that the administration is grappling with and has been grappling with since it came in. Hundreds of people have been transferred off of Guantanamo. There have been 44, I think, that have been transferred off in the last 2 years. So there's been a significant uptick in recent transfers. But the population that President Obama inherited was in many ways a difficult population to transfer and became more so after the Christmas bomber, when he imposed a ban on transfers of Yemenis back to Yemen. So there's 75 Yemenis on Guantanamo. There's a big question about what you do with them. For a while, it looked like the security situation in Yemen was improving and some could be transferred. Now the situation has obviously significantly deteriorated. One question has been, could you get Saudi Arabia to establish a rehabilitation program? Would it be consistent with human rights? And could we ensure that it was both consistent with human rights and our security concerns? To date, that hasn't happened. So just big question mark over the Yemenis. A few other countries have taken them. The other people, we've gone around the world sort of cup in hand, begging other countries to take them. And Cliff Sloan was extraordinarily successful in getting a major uptick in transfers, despite the fact that every transfer has to come with detailed security arrangements and also detailed human rights protection, non-refoulement arrangements, and sometimes other incentives to get the country to take them. The fact that we haven't taken any makes it very hard to get some other countries to take them.
Yeah, I guess I kind of feel an obligation to answer, since I was theoretically responsible for transferring all these people, and I completely failed, and that's why I'm on this panel now and not still in my old job. But I didn't know you just picked questions to answer. But I think your questions
Academics do.
Yeah, I didn't know. That's why I didn't raise my hand at first, because your question was harder. But I think your questions were very good. And in fact, the issue of whether closing Guantanamo means moving them somewhere else is really key. Because we didn't really, by starting with the specific, you kind of don't start with what the paradigm is in the first place. I think the reason it's hard to transfer these people from Guantanamo is we're still at war. Whether we should be still at war or not, whether you agree that it's a war or not, that's a very legitimate question. But when we are still at war, transferring the people who themselves claim to be at war with us is a very difficult thing. Now, the phrase that you used, Jennifer, and I think it was cleared for transfer or something like that, that was used by the press for 3.5 years that I was in charge of detainee policy. It was very frustrating because the actual verbiage was cleared for transfer with appropriate security assurances. And everyone just skipped that. And then you'd get things in the press that would say things like, there are no threat to the United States. In fact, I remember I had the honor of answering the city council of Amherst, Massachusetts, that had written to the president and said, we will happily take all of these innocent victims into Amherst and let them live in our town because we feel so bad for the way they've been treated so many years. And the way it works when people write letters to the president, apparently he doesn't answer them all. And it works its way down to the lowest level person that is willing to answer. And when you're as low as I was, you have no choice. And I wrote to the city council and said, no, you don't really want all the people in Guantanamo. And I think that's important to realize. Sometimes these security assurances, they were determined by the original committee in the first year that was responsible for going through each and every detainee. And I would say there's been no government on the face of this earth that has tried harder to take the then 250 detainees and figure out a way to get them out of Guantanamo. Every individual person, and every person that was put in that latter category that you mentioned of continued detention was personally voted on by the principals, meaning the Secretary of State, Hillary Clinton, the Attorney General, Eric Holder, the Secretary of Defense, Bob Gates, every single one of them individually with their dossier in front of them. I don't think there's many other governments that have done that. They tried very hard, but then when you look at it and you realize we're still in an armed conflict, this person still believes themselves to be at war with us, and we need to get appropriate security assurances, and what was appropriate was a little tougher to get than people might realize, especially when many of our allies did not consider us to be at war. So they're not going to give the types of assurances that a country at war would want with its prisoners of war. So I think we had a major disconnect. And that's not the fault of any individual person in government. It's the nature of the conflict.
Sure. I mean, first of all, the people who have been cleared for release, with appropriate security guarantees, there have been a range of people in that category. The vast majority today are Yemeni, but historically there have been, there've been Uyghurs, the whole range of people. Many of whom the difficulty was actually finding they couldn't be returned home because they would be tortured or persecuted. So you had to find a safe third country since the U.S. wouldn't take them. There's one false effort to take the Uyghurs, and Obama just wasn't willing to fight that political battle, so he caved. But today the vast majority in that category are Yemeni. And, Bill says they're still at war. Obviously we don't have access to the, to the individual files, but I would be surprised if people are being cleared for release if they consider themselves still actively at war with the U.S. Those are those are the ones who are not being cleared for release, I suspect. And so, what the U.S. is looking for, presumably not release to detention, because that's not really release. So they wanted some kind of monitoring capacity. And, Yemen has been chaotic even before it fell into complete civil war in the last couple of months. Now, at some point you do have to ask, is it worth it detaining these people? Because there are, lots of people around the world who pose security threats to the United States. And Yemen is probably full of them. But we don't just systematically detain them. The reason that we're bothering with this discussion is because Obama inherited this problem. He had them. And so, these are treated differently, but not on security grounds, on political grounds. And I think it's important to recognize this. We have a Willie Horton problem here. In other words, if Obama simply didn't arrest some random person in Yemen who poses a security threat, it's no skin off his back. He has a general duty to protect America, but nobody's going to blame him. But if he releases somebody from Guantanamo who then joins in terrorism, he fears the Willie Horton effect. And you're probably mostly too young in this room to remember who Willie Horton is. But Michael Dukakis, when he was running against Bush Sr., previously as governor, had released on furlough a man who I think had been a rapist, but then proceeded to murder somebody. He committed a serious crime. Maybe it was rape, but there was a serious crime he committed. And the Bush team just tarred Dukakis with this. You let out this criminal. You're responsible. And that's what Obama fears. That there would be some of these people who return to terrorism. Now, this has happened already. According to the Pentagon, quite a number of the people released from Guantanamo by Bush have returned to terrorism. And it's not as if Bush's legacy is severely tarnished by that fact. Recidivism happens. A significant number of people released from regular U.S. prison return to crime of some sort, including violent crimes. So, this is something we live with. We don't say, no, we're not going to release American prisoners because they might be recidivist. We just accept that, there's a certain risk here. And obviously in Yemen, it's not as if the United States is without its defenses. There have been the drone attacks. There, until recently, has been active cooperation with Yemeni security forces. Today the Saudis are bombing. So it's not as if there are no ways to deal with this. And you have to ask, are these random 49 Yemenis a part of a broader 57 people cleared for release? Do they really pose such a severe security threat that the United States is justified in tarnishing its reputation and providing this incentive for people to continue their fight of terrorism? Or is it just about politics? Is it just about Obama not really being willing to take the risk? And I think it's the latter. I don't think we should be looking at this as a security problem. This is a political problem. This is a failure of political will, a failure of political courage, and let's just call it what it is.
Well, just to show my independence for my ex-boss, I will cite the case of a former Guantanamo detainee cleared for release, attended the Saudi de-radicalization program. He was deemed de-radicalized, and then he went to Yemen to become part of al-Qaeda in the Arabian Peninsula.
These things happen, exactly.
It happens, so, okay.
But, and did the sky fall? No.
A drone fell on him, actually.
I did.
Yeah.
So here to share her studies on recidivism, I'll ask Mary Beth to discuss her work on these issues and tell us some of her conclusions. And if she can, maybe suggest what kind of facilities she might want to see made available to Yemeni detainees, if there's a possibility for rehabilitation or retraining or those.
Yeah, so I study terrorist recidivism, which I'm just sort of getting into. Most of my work is focused on terrorist disengagement, but obviously recidivism is the opposite of that, right? So if we want to prevent people from going back to terrorism, we need to know why they stay out of terrorism. And I guess I just want to sort of precursor what I'm going to say with recidivism rates is that it's not about, I'm not intending to scare you, and I'm not intending to say that these people should remain in Guantanamo, but I guess my aim is to sort of think about how we can address the risk that these people might pose, right? How can we reduce the risk in a humane way? In terms of recidivism rates, I've done some work. So I think there are a couple of things. The recidivism statistics that are put out by the government, I think that they're a little bit deflated compared with the studies that I've done. So in terms of measuring recidivism, there are two problems. One is that the time horizon, right? So a lot of people go back to terrorism not months, right, after the release, but years. So for some people, it might take 5 years, it might take 7 years, and we just don't have right data on that yet. The other problem is intelligence, right, which is especially problematic if we repatriate people. So we don't have accurate intelligence on whether or not people recidivate. So what I've done is independent work looking at terrorist careers and looking at how often people go back to terrorism, using independent data through interviews with former terrorists and analysis of autobiographies. And so through the analysis of these life histories, what I found is that the actual recidivism rates for after imprisonment, so after a terrorist is apprehended and put in prison, is actually about 64%. And actually, if you look at their first imprisonment, it's actually 71%. So these are much, much higher than the government statistics suggest. And actually, I mean, this isn't actually all too surprising. So as Ken mentioned, right, with criminal recidivism, the rates are actually about 40 to 50%, right? So this isn't, I guess this isn't, unique to terrorism, right? So as he said, violent offenders, I mean, it's a common problem. And the question really is how do we address it, right? And I think I would add, too, with terrorism, in contrast to criminal recidivism, you have people who are deeply, many of them, not all of them, but many of them are deeply committed to an ideology, right? So that's an additional sort of aggregating factor, right, that would explain why that recidivism rate is higher. In terms of programs, I'm a little concerned about your suggestion about the Saudis running a program, just because even though they boast these low recidivism rates, most of the ones who have fled and gone to AQAP, the former Guantanamo detainees, actually went through the Saudi program. So I'm a little bit concerned that would actually work. And the problems with these programs is that we just don't have any good data, right, on what works, what doesn't work. So I just think having sort of clear objectives for these programs, clear metrics. If we are going to have a program, it needs to be based on empirics. And even if we use the program to sort of develop those empirics, I think there just needs to be clear stated objectives. And in terms of preventing risk, I think one of the key things I found is that, there's no single reason why people get involved in terrorism, right? So for some people, they're committed to the ideology. For others, it's about money. For others, it's about friends. And so it's finding out what sustains involvement and motivates involvement for that individual. And so you really need an individual targeted-based approach, right? If you de-radicalize somebody who's not radicalized, right, that's not really getting to the root of the problem if their involvement's motivated by friendship or something else. So that's what I'd suggest.
Thank you. Well, I guess we could probably spend all day on the first question, but I will go on to our next group. And I wanted to look at those slated for military commission trials. We have 7 currently slated. I guess there's a potential of others being referred for prosecution. So the U.S. May have authority to conduct the military commission trials, and we might have divergent views on the panelists to that, although there is a strong tradition of military commission trials of law of war issues. But pragmatically, I think maybe all the panelists would agree that the current military commissions have proceeded very slowly. There have been many legal challenges. Some of the charges have been overturned. And wouldn't we have been better off starting with federal court trials to begin with? And if Congress reversed the ban on individuals coming to the U.S., couldn't some of these individuals be tried in U.S. federal courts? Who would like to tackle this one.
Again, I feel an obligation, so I'm going to have to talk eventually. What wasn't in my in the bio that Jennifer shared is that prior to this administration, I was in charge of setting up military commissions in the Bush administration. So I just follow success after success. But I'll answer the question yes. I can't remember what the question was, but the answer is yes. Could they be tried in federal court? Absolutely. And frankly, could they be tried more easily in federal court? I believe so. If you look at the very first commissions set up, which were over time resoundingly criticized before there had ever been a trial, one of the things that was not there in the list of potential crimes was material support to terrorism. People would come to me as the guy in the process, as a law of war expert in the Marine Corps, asking me questions about, well, these military commissions, these will be much easier to deal with, these terrorist trials, won't they? Well, no, in some ways they're easier. You have evidentiary issues that might be a little easier. You can protect classified material a little bit easier. But what I would frequently say is, but the Department of Justice has this charge, material support to terrorism. There is no war crime that is going to be nearly as easy to prove as material support to terrorism. So at a later time, when the Supreme Court had knocked down the original military commissions and Congress came in with a new law, they added material support to terrorism. Somebody had been listening. They missed the point. But they added it, which has now been knocked out by subsequent courts. So when the beginning of the Obama administration, they were looking for numbers of people that they could prosecute so as to reduce the number of people at Guantanamo. The Department of Justice came up with a number, and then the military commission team raised their hand, I was not there, and said, oh, we can double that number. Well, maybe if they had that material support to terrorism, but I think it was a bit inflated. And if you were to ask me right now, it would be easier to prosecute most of these people in federal court. That has been true from the beginning. I think in the very beginning, people didn't know how they intended to use military commissions. Throughout history, military commissions have always been a court for exigent circumstances, and one can question whether there were exigent circumstances in 2002 is one question, whether there's exigent circumstances in 2015 is another question, and I think, so that's the way I look at the commission piece.
I don't know if Ken and Sarah have anything to add.
I agree. I think it was an enormous mistake for the president to continue the military commissions in this administration. He did it for the reasons Bill said. He thought it would help draw down the numbers on Guantanamo, but it would never have drawn them down significantly enough, I think, to justify the expense, the uncertainty, and the illegitimacy of these institutions. I mean, even if you got durable convictions from them in the end, which we have not to date, the rest of the world wouldn't view them as legitimate, and so, you know, they're sort of a product of original sin, and we would be much better off in federal court.
If I could just add one quick thing to make clear when I'm talking about commissions, I think to myself I'm talking about something completely separate than holding people in Guantanamo. While the president in his original assessment was really looking at ways to remove or to reduce numbers, frankly, our authority to hold someone in Guantanamo is because of the position that we're at war with al-Qaeda. It's very different than the recidivism issues in a criminal enforcement context. Every one of the detainees in Guantanamo has had access to the U.S. courts and can challenge their detention if they want to. They're completely incapable of challenging it successfully by saying, we haven't been prosecuted, or I'm not a criminal. You know, in the United States, we had 425,000 prisoners of war at the end of World War II. They weren't going to court to get prosecuted. They were, in fact, released at the end of the war. So two different issues, and I just want to be clear about that. When I comment on commissions, I don't think it's directly related to the issue of closing Guantanamo.
I mean, let me just add to this. I mean, I agree. The military commissions have been a complete disaster. But it's worth explaining why we have military commissions. Because there are really two big political motivations for the decision to have them. One was to keep out evidence of torture. And the Bush administration and on into the Obama administration went out of their way to try to avoid making it possible for anybody being prosecuted to be able to get evidence of the CIA's torture into court. And so if you look at the military commission rule of evidence, they're actually very cleverly drafted. They of course say you can't introduce the coerced statement of the defendant. That would be going too far. But there's no requirement that the statement of witnesses be voluntary. And there's also there's a hearsay. The hearsay rule is suspended. And so basically the evidentiary rules are designed so that the government can make the case by having sort of the supervisor of the supervisor of the supervisor of the CIA interrogator describe what happened in that room, at least the results, but knowing nothing about the torture that happened. And in any event, voluntariness isn't a factor for the introduction of the statement of this mere witness against the defendant. So, this is just one dimension of why the military commissions have no real legitimacy. You got to say, well, why are they bothering today when the Senate Intelligence Committee put out this massive report about the torture? And while we don't know everything, we certainly know enough so that there's no real need to be fighting the evidence of torture that a suspect might be introducing in his or her defense or his defense. So, that rationale is kind of gone. The other big rationale was just this political sense that we're going to be tough. These are terrorists, and we're going to be tough with them. And doesn't military sound tougher than civilian? Yeah, right? So we're going to try these people in a military commission because we're not going to be softies and put them in a mere civilian federal court. Now, as it turned out, that wasn't so smart because the federal court, first of all, as Bill and Sarah say, it would have been much easier to convict them because you have things like material support for terrorism, which doesn't exist in the military commissions. Plus, the military commissions have basically been created out of whole cloth. And so whenever you have a brand new court system where they're kind of making up the rules as they go, you get delay after delay after delay after the judge is trying to figure out what should be the rule here, and then it's appealed. And in the meantime, you've got all kinds of problems like the FBI snooping on the lawyers and the interpreter turning out to have been an interpreter during the CIA interrogation. And these problems keep coming up. And so you take the 9/11 case. I went down. It must have been 3 or 4 years ago now. I went down to see the arraignment in Guantanamo, and it still is going no place. Whereas if we tried them across the street in the Southern District, this case would be done with. It would have been seen as a fair trial. These supposed severe security threats. I mean, I spent 4 years as a prosecutor across the street, and we tried big terrorism cases. We tried drug trafficking, mafia cases. Nobody even notices. You kind of walk down. Foley Square. I mean, nobody has any idea that there's a big case going on in the courthouse. And the idea that this would have, paralyzed southern Manhattan is absurd. Or if they really were worried to move the trial to Governor's Island or something, But I mean, it's just, this is not about being tough. This is about politics, about pretending to be tough. And Obama, got it right for a while. Holder wanted to try them in Southern District. And Obama was willing to stand with him until there was a political price to pay, and then he caved. When the Republicans and Bloomberg started objecting, he was not going to fight that political battle. And that is, frankly, the story of Guantanamo over and over again, is that, Obama in an easy world would have closed it a long time ago. But it's just not a priority for him. He's not going to spend the political capital. If there's too much pressure on the other side, he capitulates. And that's why we have military commissions today rather than civil, federal court trials.
Do you want to get a little response?
I can't let the one thing go, Ken. Ken's second point, I completely agree with. I think every statement you made, even the political part to some degree, though I think we may come out differently as to which way politics push and which is the best result. And as a former prosecutor, absolutely. And you're absolutely right about the tough. I remember how many times I would take congressmen down to Guantanamo, and you could tell when they had kind of staked their political position, and it would drive me crazy on the, for lack of a better term, left and right. You'd have, why haven't we closed the place already on one side? And you'd have to explain, well, this is an armed conflict, and there are reasons that you hold people prisoner in armed conflicts, whether or not they've committed crimes. On the other side, completely, that's why I'm concerned about the two different issues, was we got to be tough on terrorism. This is a war dog on it. We need to try and buy military commission. Okay, the fact that it's a war has nothing to do with whether you're choosing military commission or not. Prosecuting somebody is bringing them to justice for past acts. Holding someone as a prisoner of war is future threat. Two completely different things. I agree with all of that. It just took too long to do that, I'm sorry. But what I can't agree with is that one of the first reasons was to somehow keep torture evidence from coming out. I was there writing the first rules. I assure you, at no time was I considering writing rules that would protect the evidence that someone had been tortured. The other thing that you frequently hear is right now, the reason we haven't prosecuted more people is because it'll come out how they were tortured. Look at all the people in that Senate report. They're all being prosecuted. So I don't know who it is that we're not prosecuting because of torture evidence. The original rules were written to protect intelligence because at that time, they didn't know where the armed conflict was going. They didn't know what intelligence will need to, you don't usually prosecute people during your armed conflict. A couple dozen people were prosecuted in Nuremberg after the war was over. They talked about doing it during the war, but the fear was you'd be ending up giving away too much intelligence if you're going to have a fair trial. So you have to use information during your trial.
I think we could stay on that question, but I will move us along to, I want to reach the category, our third category of whether we call them indefinite detainees or law of war detainees, whatever term we choose to use. There were 55. Some may have been referred to for prosecution, so that number may be lower. Regardless of the exact number, is the U.S. entitled to hold anyone in this category? And given the acknowledged 2014 end of combat operations in Afghanistan, and presumably a number of these detainees are individuals who were obtained in conjunction with that armed conflict that we now have admitted has reached its end of combat operations. Sarah.
So international law allows you to hold enemy fighters until the end of hostilities, right? So if you're in an armed conflict, you can hold such people. So one question is, are these people those people, right? And what is the conflict pursuant to which they're being held? And if you assume that those people are, in fact, people who are fighters in the conflict with Al-Qaeda, the Taliban, and associated forces, now we get the question of, are we still in an armed conflict with those people? And of course, if you listen to Stephen Preston's speech at ASIL a week or so ago, he listed various groups that the US considers itself still at war with. That includes Al-Qaeda in the Arabian Peninsula, ISIL in Iraq and Syria, some members of Al-Shabaab in Somalia, as well as, among others, Al-Qaeda and the Taliban. Now, the people on Guantanamo were picked up with respect to the conflict against Al-Qaeda and the Taliban in the AfPak region. And it is my view that that's the relevant conflict. If that conflict is still ongoing, you can hold fighters that were engaged in that conflict. Once that conflict ends, you can't hold them because we happen to be fighting someone we consider an associated force in Yemen or in Syria or some other part of the world. So the critical question is what's going on in Afghanistan, Pakistan. Stephen Preston, General Counsel to the Defense Department, announced in his ASIL speech that the administration considers itself to still be in an armed conflict with Al-Qaeda and the Taliban in the AfPak region, despite the president's perhaps overly optimistic announcement last year of the end of major combat operations. And I think my personal view is that given the ongoing hostilities in that theater and given the level of US engagement, that's true for now. Some of the Guantanamo detainees have filed habeas petitions relying on the president's position that combat operations had ended to say, well, once hostilities end, we get released. That's also true as a matter of international law. You have to release at the end of hostilities. And I think that's one thing that many of the people who are very enamored of law of war detention forget, which is that it's not an indefinite ticket to be incarcerated. It's tied to the end of the conflict. But I would say in the near term, there is probably still legal authority, I think, for holding the Gitmo detainees. And it will depend on how long we remain engaged in hostilities in Afghanistan.
No?
I mean, I would agree with what Sarah said, except that I'm much more skeptical about whether we're still at war in Afghanistan, because there is still a war in Afghanistan, but that's not the issue. The fact that the Afghan government is fighting the Taliban doesn't justify the U.S. holding people pursuant to that war. So the question is, even though the U.S. is supposedly not engaged in combat in Afghanistan, can they still claim that they're at war? And it becomes logically complicated to sustain the administration's position that we're not fighting, but we are at war. But that's basically the administration's position. It's also worth, the reason we've been talking about this category, I remember meeting with Obama early on in his term about how to close Guantanamo. And this category came up. At that stage, they talked about them as people who are too dangerous to release, but we can't try them. And can't try them because they were tortured or because they don't have the evidence or whatever. But something about their conduct in Guantanamo convinced the jailers that these people were determined recidivists. But trial was going to be impossible. And that, we never really understood how they made that decision, because there's no formal process at that stage. There's never been anything like a hearing. They just, the government just decided these people are too dangerous. And at first people tended just to kind of accept that at face value. But when you start looking over time, these people who are absolutely too dangerous, unredeemable, determined recidivists, suddenly the number started decreasing. And it used to be that there were 48 people. Now I think there are 2 died, but there are 33. So that means what? If my math is right, that there's another 12 or 13 or something who suddenly weren't so unredeemable and maybe didn't pose such an impossible threat. And so even though the cleared for release is with conditions and all, these people look much less terrifying when you recognize that even the government itself has switched a number of these people out of this category. And again, it comes back to, how severe really is this risk? Is this risk different from the risk posed by a gazillion other people who are running around Yemen or Iraq or Syria? And is this really just about Obama not wanting to risk the political cost of releasing somebody who may turn out to be a recidivist?
I think I would factually disagree with Ken in terms of how dangerous they are and how likely they are to become recidivists with respect to this particular group. But I think I'd completely agree that and I would also agree that when the war starts and ends is absolutely the real question. That's what I think the focus of our government should have been, much more, and of critics should have been, much more so than closing Guantanamo. I think closing Guantanamo was a red herring that caused us to miss the real issue, and that is, when is the armed conflict over? I think these guys are still a threat. They're a significant threat. I think even the ones that have been moved in terms of categories are still a significant threat, because there's a lot of pressure to move them, because there's a lot of pressure to close Guantanamo. I think in that regard, there's political pressure that goes the other way from what you're worried about. All that said, I think when the armed conflict's over, we release them regardless of that threat. I think an earlier statement was made that, hey, the world didn't end when certain people got released and recidivated. Well, no, but people died. There are innocent people dead because Guantanamo detainees that we had formerly captured killed them. That's significant. That said, I would still be willing to release them. We released many people after World War II who were bad people. They weren't criminals, but there were people who caused a danger to us. We do it every day in a criminal context, as you've pointed out. And I think the rule of law requires us to do that, even at our own risk. And I think Sarah's right with respect to when the conflict's over. I think legally you have to release them, regardless of whether there's a way to mitigate the threat. The place I might disagree is whether the geographic limits of Afghanistan is what defines the war. I think when we have drone attacks taking place in other places against the same force that the AUMF is saying, when the argument is made by Steve Preston that we're in an armed conflict with this group, I think that it's not geographically limited to Afghanistan. The real question is, are we in an armed conflict with that group? Should we still be in an armed conflict with that group? And how are we going to bring that armed conflict to an end? I absolutely think it's in this nation's interest to close Guantanamo. I'm a little bothered by not having more prisoners, not taking more prisoners, not keeping prisoners while we're killing people. You can't kill people and not be in an armed conflict. And if you're killing people, you need to be able to detain them too.
So just on the lumping all the groups together, right? If you lump all the groups together, then the war is never going to end because there's always going to be some new group with which you're in a conflict somewhere in the world. And the reason that the United States lumps all the groups together is that in order, as a domestic law matter, in order to have domestic legal authority to be using force in armed conflicts, we've only got one authorization of the use of military force, and that's the 2001 AUMF. So everyone has to be hung on that Christmas tree like an ornament as a matter of domestic legal authority. Under international law, these are separate conflicts. And it's international law that governs, the ability to detain law of war detainees and when you have to release them. And so for that reason, I would say it's the AFPAC theater that controls when the Gitmo people get released. Now, you might be able to establish on a individualized basis that a particular Guantanamo detainee, was committed to the cause of Al-Qaeda in the Arabian Peninsula, and that they would go back and join that fight immediately. But I think the burden would be very high to establish that if they had not been picked up as part of that conflict to begin with.
So I guess what we've kind of been skirting is really where and who, against whom are we at war, and therefore when we have to release, how do we measure this? And we have very dramatically different views on, do we do it theater of operations by theater of operations, or Stephen Preston suggested we're at war with Al-Qaeda, the Taliban, certain other terrorists or insurgent groups in Afghanistan, Al-Qaeda in the Arabian Peninsula, Al-Qaeda in Somalia, Al-Qaeda in Libya, and also more recently the Nusra Front, Al-Qaeda referred to as the Khorasan group in Syria, Al-Qaeda in Iraq, now known as ISIL. And I think Sarah's point is very well taken. He's doing this to link it all to the 2001 AUMF and or maybe the 2002 AUMF. But is the implication that the Department of Defense, and I know he's not here, so maybe this is an unfair question. I mean, it suggests, unless all of these are, we have hostilities ceasing, we're allowed to have detentions, or do we do a theater of operation by theater of operation analysis of what wars we're engaged in?
Let me make 2 points. I mean, my organization doesn't take a position on the AUMF. We don't get into, kind of is the use of force justified or not. But that said, the AUMF talked about Al-Qaeda, the Taliban, and associated forces. And to try to, bring in ISIS as part of that is such a stretch because, ISIS split from Al-Qaeda. ISIS believes in building a caliphate. Al-Qaeda doesn't. ISIS is perfectly happy attacking Muslims. They regularly do it. Al-Qaeda is against that. These are very different organizations. They are not associated. They are actually enemies in some ways. In Syria, Nusra and ISIS fight each other. And so, to say that they're all, authorized by the AUMF is a real stretch. So that's just, kind of step one in this. Second, whether a nation is at war in any given context is not simply a matter of saying you're at war. If that's all it took, I could just, the U.S. government could go in and say, we're at war with the drug dealers in across the street and start shooting them. Because when you're at war, you can shoot the combatants on the other side. And obviously, you can't do that. There is a substantive definition of armed conflict, probably best pronounced in the Tadic case of the Yugoslav Tribunal, which looks to the degree and intensity of hostilities, the organization of forces. And while there's no question that there are armed conflicts in different parts of the world, so if you take right now Syria and Iraq, I would say the regularity of the U.S. bombing there is sufficient to say that that's an armed conflict. Certainly in Afghanistan, until the termination of U.S. combat, that was an armed conflict. If you look at Yemen, I think it's a real tough case to argue that that's an armed conflict with the United States. There is an armed conflict among the Houthi and the residual Yemeni government, and AQAP is now entering into that. So there's a mess of a civil war. But basically, the U.S. involvement is shooting off an occasional drone. They're now putting a few boats around Yemen to try to deter the Iranians from supplying the Houthi. They're providing some intelligence. None of this adds up to the regularity of armed force that, by an objective standard, would constitute an armed conflict. And so for the United States to say, oh, but we can, launch an occasional drone because we're at war in Yemen, is not that different from going across the street and shooting a drug dealer. And in fact, when you look at Obama's speech that he gave at the National Defense University, I guess now almost 2 years ago, he deliberately kind of backed off calling Yemen an armed conflict. And he articulated the alternative standards that apply. Because even if it's not an armed conflict, you can still sometimes use lethal force, but the standards are policing standards. The question is, does the person pose an imminent lethal threat, and is there no alternative way of addressing that imminent lethal threat? And he said all that, but it apparently isn't really being applied, because the concept of imminence seems to be incredibly elastic. So it's not, is the person kind of about to board the plane, but rather, might there be some future plot that they're engaged in? And it's not even clear to what extent there are efforts made to capture. We recently saw a case in Pakistan where somebody had been on the kill list, approved to be droned, and then they suddenly were arrested. And so it makes you wonder, well, what about the others? This person happened to be a U.S. citizen, so they made a special effort. But if, in that case, well, why not others? Why aren't they trying to arrest these people? And he was on this kill list for quite some time. So how imminent was the threat he posed? And so, what I'm left with is that in places like Yemen, I would argue actually also Somalia, there's not an armed conflict with the United States. So war rules don't apply. Policing rules should be applied. And the U.S. isn't following them, even though Obama kind of articulates them. But it's, it's Professor Obama speaking. It's not President Obama. He says these things, but nobody follows them. And that's, I think, where we are right now.
Bill, is this one linked war or different fronts in terms of repatriating detainees?
Well, to be consistent with the way, realize my former job was detainee policy, not Guantanamo policy. And when I would describe the situation, we had, at that time, detainees in Iraq, we had detainees in Afghanistan, we had detainees in Guantanamo. And so for me to change now would be a little bit inconsistent, and I won't, because I think it's right. What I used to say is, in Iraq, it was a counterinsurgency. We were at war with the factions that are now incarcerated, but we're transitioning. The insurgency is ending. We've now shifted to a law enforcement paradigm, and we have to get rid of these detainees and move them into either into the law enforcement world in Iraq or release them. In Afghanistan, we were in the midst of that shift. And I agree with one of the suggestions Sarah made, that at some point when we talk about ending combat activities and things like that, there's a real question as to when does the armed conflict there end. We began shifting, doing that same kind of a shift of the detainees into the hands of Afghanistan. And I'll say right now, within Afghanistan, at that time, the Afghan government viewed it as a law enforcement scenario. So when we were shifting them, they were in a law enforcement world, and sometimes there wouldn't be enough evidence to hold them, and others would be released. I believe the same thing can be the case with respect to the conflict, what I would have said until the Preston speech and before I left government was Al-Qaeda. And I would have said that those members of the Taliban in Guantanamo, on the day that we cease combat activities in Afghanistan, the Taliban goes home. Al-Qaeda, we're still in an armed conflict with, and the one place I would disagree with you, Sarah, is the geographic requirement. I mean, I just, for the first time, saw the new World Trade Center outside this building. Beautiful. And I realized that was part of the theater of operations at one point. So to geographically constrain it to where you capture somebody doesn't seem right in modern warfare where you have a transnational armed group that has nodes all over the place. It was never required under the law of war even in World War II or World War I. It was rare that you would find any appreciable force outside of a normal theater of armed conflict. But now that we have nuclear weapons and much more devastating capabilities, it's going to happen in the future. So we need to have a concept of an armed conflict that is not geographically limited. And that way, I think both Bush and Obama got it right when they said, well, one said global, but in at least legal opinions, the other has said global as well. So I think the real question is the one that Ken touched on, which is it an armed conflict or not? I wouldn't agree that I would elevate the significance of a state's claim. We don't want to mix the jus ad bellum and the jus in bello, the law of when you can go to war and the law of what rules apply when you're in war. The jus in bello rules and some of the Tadic language is designed to make the case for when the rules of war are applying. It's not designed to define when it's a war, and that's what's happened in recent years as people have looked at it because of the very concern that a country could just say it's at war. I think the protection against a country just saying it's at war is you criticize them for going to war. If you say you're going on a war against drugs, everyone in the United Nations should be standing up saying that's absurd. We do not accept that in the international community, that you can go, against drug dealers and have a war against them. After 9/11, everyone did not stand up and say we couldn't go to war against Al-Qaeda. That was a different scenario. I think, and I do think there's an end game here, even if it's whether they're conglomerating them or making them discrete. I think the end game is not that there won't be another threat that emerges. There's going to be a terrorist threat that emerges. Most of our allies deal with the terrorist threats as criminal law enforcement matters. I think this kind of war, my opinion would be, it's not going to be a peace treaty. There's not going to be any signing on the Missouri. But the state, the more powerful state, is going to decide when the armed conflict is ended. They're going to decide that it has ended, and the decision will mean we're now shifting back to the law enforcement paradigm that we were using before 9/11. I do not think it was wrong to go to war. I think while we're at war, it is not wrong to detain people. They're prisoners of war, and you detain prisoners of war. To try to condemn detaining prisoners of war is effectively incentivizing killing, because then that's the only way to take out your enemy. But I think that you can't live in a world where war lasts indefinitely. And the focus of our attention should be determining when that war is at an end and getting to that point in time, not determining how to close Guantanamo.
Bill, if we link all of these, and there has to be an end of hostilities against Al-Qaeda everywhere globally, doesn't that risk putting us maybe not on an indefinite war footing, but a very, very long-term foundation that we're not using policing methods and we're able to use detentions and drones for a very long period of time? Because it sounds like the implication of Preston's remarks are that, as long as we have a threat from Khorasan Group, Al-Qaeda in Iraq, or Al-Nusra Front, or Al-Qaeda in Somalia, or Libya, Al-Qaeda in Yemen, etc., as long as we still have one of those, are we allowed to use the Law of War Foundation? Sarah's eager to take this question.
I don't think he said that.
Okay.
I mean, I think he said these are the groups with which we are in an armed conflict.
Yes.
I do not think he said, and we consider them all the same armed conflict.
No.
And we release.
No, I'm kind of pushing, but isn't the implication, where I'm still coming back to, are these different wars, or is this one linked war? And it has profound implications for when we're able to use lethal force and our detention abilities.
My guess is that the government doesn't really have a clear position on this. Some of them it considers more linked than others. I mean, but if you take ISIS, right? ISIS would have been part of the counterinsurgency that you were, detaining in Iraq, and that you would have considered subject to release at the time that we left Iraq, right? And now, and that would have been under the 2002 Iraq AUMF. And now we're fighting them under the 2001 AUMF as a, splinter successor to Al-Qaeda that is, hostile to Al-Qaeda. That conflict can't be the same armed conflict as the conflict with Al-Qaeda and the Taliban in Afghanistan. So, I mean, that at a minimum has to be different.
I tend to agree factually, though I don't, Steve Preston talked about, I also defer to the intelligence that talks about them as a successor organization. I don't know. So I defer to those more knowledgeable on the factual scenarios, but I absolutely agree with the concern. I think that is the biggest threat we face. We face the threat of a quasi-war that just goes on indefinitely. And frankly, I'm going to blame everyone here partially who happens to have been so focused on the closing Guantanamo, because I think when you try to make a clean war that doesn't have detainees, remember what happened when President Clinton briefly kind of went to an armed conflict paradigm after the East Africa bombings. There was Tomahawk missiles into Afghanistan, Tomahawk missiles into Sudan. There was some criticism. It was over. People didn't debate anymore whether it was appropriate to use force in those circumstances. There were dead people, but there were no prisoners. The same is true on many discrete attacks. There's criticism now of the number of drone strikes, but it's amazing how short-lived was the criticism for any discrete single one. That's not true of a detainee that persists. That's a good thing. It should not be comfortable to stay at war for indefinite periods of time. But we shouldn't try to clean that war up more by getting rid of the detainees that remind us we're at war, and then simply have uses of force that are taking place in far-off places, killing people. I think if you've moved to a law enforcement paradigm, true, you can't detain someone unless you've convicted them of a crime, but you also can't kill them without a trial. And there's been a little bit of a debate on whether we have a new normal, and there's something in between war and law enforcement. I think that's a very dangerous thing. I think that we don't want to live in a society where in peacetime people can be killed without a trial. But we shouldn't so fear the idea that someone could be detained without a trial if we are in war. The goal should be to end the war.
If I could just add here, there was massive detention in Iraq during the war, which, Abu Ghraib was controversial over the torture, but it wasn't controversial over the detention per se. So, Americans rightfully accept that detention is part of war. What makes Guantanamo, much more objectionable is the sense that for a vast majority of them, either the war is over with or they were picked up for the wrong reason, but it's just too politically embarrassing to release them. Or, there are a variety of other factors. Or, some of them should be prosecuted, but they're not getting a fair trial. They're being handed to the military commissions. So it's not that, detention in war per se is the problem. I think the other real factor here, which we should just admit to, because here we are in the United States, Americans are much more comfortable with things like drones because we think about them as things that Americans do to other people. We don't think about it as something that can be turned on us. But I think you've got to think about it both ways. And let's, put ourselves in the minds of Vladimir Putin for a moment. He's had a war in Chechnya, now there's one in Dagestan. He can come up with a war. And he, in fact, has, working through Ramzan Kadyrov, killed combatants in that war, in Vienna, in London, and is there anything wrong with that? Should we say that this is just a war? In a war, you can kill the combatants wherever they are. It's a global war. We're not geographically limited anymore. This can happen any place. And that, when Putin does this, we rightfully say, I think, this is wrong. This is just executions. But when Obama does it, we say, well, we don't really know what the geographic limits are of the war, and Al-Qaeda is globally dispersed, and we're not going to really treat the Tadich case as having to do with the appropriate use of lethal force. And and I think we have to recognize that the effective monopoly that the U.S. has today on drone technology is going to be a short-lived monopoly. And there are going to be lots of people with the capacity to deploy killer drones. And if we don't get the rules right during this monopoly period, we are going to suffer the consequences down the road. And I think we're just being very short-sighted by doing it because we can without looking at whether it's the right thing to do.
Both Bill and Ken are bringing up the interrelationship between detentions and drone strikes, and just the irony that under the Bush administration, they're increasing detainee, and then we have detainees in Guantanamo, which is visible, and maybe less visible are the impacts of drone strikes, a policy that dramatically increases under the Obama administration. So I think Bill is suggesting, as much as it sounds good, Guantanamo must be closed and we, must not have this facility. Doesn't the U.S. need detention facilities, and isn't it potentially a lot scarier? I think Ken is also suggesting this use of drones. In some ways, aren't detentions the benign aspect as opposed to drone strikes? If we don't detain, we're doing targeted killing.
Well, first of all, again, if it's a classic war, you can detain until the war is over with. That's uncontroversial. But in these situations, like Yemen, where there is sporadic use of force by the United States, and it really doesn't meet an objective standard of an armed conflict, then you use the criminal justice system. And the criminal justice system is perfectly adequate to provide a long-term detention possibility. Indeed, it is probably a politically superior one because you don't generate all the animosity that Guantanamo or its equivalent would generate. You just give them a fair trial and then put them away. And some people will say, oh, but we won't have time to interrogate them and get intelligence. But in fact, under Miranda rules and the like, there is a public emergency exception. You're allowed to do a degree of interrogation before you even inform them of their Miranda rights. If the top priority is gathering security intelligence, you have two teams. A violation of Miranda triggers an exclusion rule, but you can have a clean prosecution team and a sullied by the improper interrogation security team. And so there are lots of ways around this so that you can get your intelligence, you can interrogate, but you're still not stuck with detaining somebody pretending it's a war when by any objective test it's not a war.
I'm just really worried about, going to this point about the fact that, the war ends when the U.S. says it ends, right? And so when we're combating terrorists, right, these are people, this isn't a conventional war situation, right? And so going to your point, Ken, about, maybe we're not at war in Yemen, but I mean, terrorists aren't using conventional methods. We're not fighting like we were in World War II, right? So maybe the U.S. is fighting the war a little bit differently, right? So maybe, I'm not a lawyer, so I don't want to weigh in on the legal aspects of this, but I'm just saying, when you're taking that international legal framework and you're applying it to a completely different context, you have people that are, you're fighting people who aren't operating by the standards of war, right? And they're hiding, maybe 3 people could pose a severe threat to the United States. So how do you draw that line? And I think it's going to come down to this political expediency, right? So the U.S., and that worries me, right? The U.S. is going to say the war's over, when it's politically expedient to say that the war on Al-Qaeda is over. I think it's going to come down to that, or ISIS, same sort of thing.
Well, I think you're absolutely right, but that's the danger, and that's what a principled government should be focused on, is coming up with a principled way to describe when the war should end. It can't be when there are no more threats that emerge. On the other hand, we can't say that they're just, therefore, since it's difficult, since it's different than other kinds of wars, it's not a war. In October or November of 2001, look at the uses of force that the United States has been engaged in since the UN Charter. And in almost every instance, there's been a hue and cry after that use of force where many countries have disagreed that it was appropriate for the United States to use force. Now look back to the General Assembly and the Security Council when President Bush gave his first speech after 9/11 and when we started putting boots on the ground in Afghanistan. You did not have that. In fact, it was the French ambassador to the United Nations that drafted the UN Security Council resolution that spoke of right to self-defense. It's the first time the Washington Treaty, the NATO Treaty, talked about an Article 5 defense situation. SATO, same kinds of things. So it was widely accepted around the world at that time that war was an appropriate thing to engage in. I've already said and I think I can join Sarah too, because we were both in government, but we've said that it was probably a mistake to keep commissions alive. So I'll also say what I think was President Bush's mistake, and that was not calling the people in Guantanamo prisoners of war. I think he should have used that term from the beginning. Yes, I understand why it was not used. There's a technical legal issue that the Third Geneva Convention doesn't quite apply to these people because the circumstances that these legal regimes were built around don't quite apply. But in the Civil War, you know what? We called all the prisoners on both sides prisoners of war, and they wouldn't qualify for that status under the Third Geneva Convention either. There's a dictionary definition and there's a legal definition within a treaty. It would have been easier to explain how the Third Geneva Convention doesn't quite apply than it would be to explain how it's not a criminal justice paradigm. That's, I think, what went wrong with Guantanamo, even more so than it being the theater of conflict. I think on the same day the president announced that military order number 1, President Bush now, and said, if a person meets these criteria, essentially Al-Qaeda or the Taliban, then it's DOD that will detain them if they're captured. And if they get tried, they will get tried by military tribunal, military commission. By sandwiching those two things together, the whole world got confused and started thinking we're in the same criminal justice paradigm we were in the beginning. And then the debacle of military commissions over the next decade just perpetuated that. When I went on my first trip to Guantanamo, when I took this recent job in the Obama administration, I looked at the tour all of our congressmen were getting. The first place the tour boat would stop would be the, what's it called? I should know, Camp Justice, which is the courtroom where these people would be prosecuted. There's no courtroom like it in the United States in terms of being able to hold classified material. It's quite a bit of money. I won't even say how much. A lot of money went into it. Anyone who gets that briefing would say, why in the world would you prosecute them in the United States when you spent all this money to build this thing? And then they go visit the detention camps, and it leaves people with the impression that these people are in pretrial detention and we're working them through. Not calling them prisoners of war, I think, caused that problem. And it allowed us to be in something that wasn't quite a war in a lot of people's minds. And I think we absolutely need to focus on defining when it ends. I completely agree it's a political issue, and this is a time for leadership. Whoever can step up to the plate, and I'm not saying I would necessarily agree as to when it should end or whether we ought to be at war with ISIS or not. The real issue is we ought to be clear in our definition of whether we're at war or not. If we're at war, we shouldn't be afraid of detaining people. And detaining people does not mean only detaining them when you have an indictment on them and you can take them to a U.S. court and prosecute them. We prosecute people for proof beyond a reasonable doubt of a past act. When you pull a trigger in war, I guarantee you we do not teach our 19-year-old soldiers and Marines, you pull the trigger after you have proof beyond a reasonable doubt that they've committed a crime. You wouldn't win many wars if you did that, and we certainly don't want to put that requirement on capturing people.
Okay, so 2 points. The first is whether or not you're in an armed conflict is a factual question, right? It means, are there ongoing hostilities between the two sides to the conflict? And a government can announce, yes, we're still in an armed conflict, but if you don't have the factual predicate of the requisite level of intensity and, duration of hostilities, you're not in an armed conflict. Conversely, I mean, the one thing that a state can do is say, we're withdrawing unilaterally from this armed conflict, pull out all your troops and stop participating in any way in the conflict, and in that way, it can be a political decision, but the converse isn't true. On the drones versus detention question, I would strenuously resist the suggestion that the Obama administration has replaced detention with lethal targeting. I mean, to detain someone, you have to capture them, right? Which means you have to send forces in and put physical hands on them and get them out of there. And most of the targeting operations are occurring in remote regions where we would not send in people to capture people and take them out because of risk to our own forces or to the forces of the relevant country. I think there's a real question whether we're trying hard enough to capture the people that we actually end up targeting. But we have an option. We can go in there, we can capture them, we can bring them to the Southern District of New York, and there are plenty of prosecutors here who are willing to prosecute them. What drones have done is that they've made it possible to kill people in very remote areas where you wouldn't send people in to capture them. So in that sense, it creates a capacity to kill where we would not have captured and detained before. And I think that's sort of the underlying creeping incentive.
I think I'll ask one last quick question, and then we'll move to audience questions if you want to start thinking of them. It plans to close Guantanamo. It's frequently been discussed, if we whittle it down to the small group of indefinites, why not bring them to the U.S. and throw them in supermax facilities? Well, we know pragmatically Congress has blocked this now, so this isn't going to happen. But to play devil's advocate, aren't the conditions a lot better in Guantanamo? And supermax is pretty brutal. This is doing no one a favor. It sounds very nice, let's close Guantanamo, but isn't this a concern?
I don't think anybody believes that you solve the Guantanamo problem by simply moving it to the United States. You either move people to be tried or you release them. But simply, having an onshore Guantanamo, that doesn't solve anything.
I think there are people who think it does. I think there are people who think it solves the perception problem and the legal black hole problem, because the United States, other than accepting that habeas applies to Guantanamo because the Supreme Court told them it did, the United States hasn't accepted that any constitutional protections beyond habeas apply on Guantanamo. So although we've applied them by statute to the military commissions, there's this big legal question mark. The ICCPR doesn't apply there because it doesn't apply extraterritorially. Thank God now the CAT does, because they said so in November in Geneva. But the perception that Guantanamo is a law-free zone and that that's why the people are there could be addressed by bringing people to the United States. Now, I do think it's true that law of war internment is not supposed to be punishment, and you're not supposed to be held in solitary confinement, in a supermax facility. You're supposed to be able to move around and that kind of stuff. And that's not what Lindsey Graham thinks about if he thinks about, law of war detention in the United States. So I think there's a real problem there if you move people. And another problem that has arisen and that some are concerned about is if you do move people here and constitutional protections apply, you will immediately get the Justice Department arguing that there are exceptions to those constitutional protections for this particular population, and you end up diluting the constitutional protections, for people on U.S. soil. And if so, isn't that a concern? So I think that's sort of the package of problems.
I think time for audience questions. In a blue shirt.
This is mostly for Professor Altier about the rates of recidivism. You said that we need more data on rates of recidivism, but with such a small population in Guantanamo now, what does that look like with such a small sample size?
Well, data are really hard to come by. And that's why, as was discussed earlier about people moving from categories, I think that just shows, right, that we don't actually have good data on how to assess the risk that these people pose. And so in terms of collecting data, I haven't interviewed people at Guantanamo. I've interviewed people who have willingly left groups on their own, right? But at some point in time, these people had been imprisoned, right, and had either gone back to terrorism or not. So in terms of talking to people who have been through that process and looking at terrorist careers, in a variety of ways and seeing how that, and looking at risks, asking them specifically, why did they go back, what sorts of factors mattered, and the process by which they went back. So just not even understanding the causes, but just how that was facilitated.
David?
She didn't know David.
Thank you very much, and thank you, Jennifer, for having put together probably the most interesting panel on Guantanamo in 13 years since it exists. It's also refreshing to hear from Bill Lizzow as a known, I've heard you so many times when you were a government official. So this was quite a different tone today.
See why they threw me out.
Now you are a free man. You're a free man. If I can allow myself to say something as a non-United States national here, I think the worst damage being done by this so-called war on terror or counter-terrorist strategy that is prevailing today is exactly what also Bill referred to, this policy of targeted killings. I cannot but remember when the deputy head of Al-Qaeda in Yemen was killed, and it was a major press conference in Washington. Result of that, now we have hundreds being recruited to replace him. There is now a clear war which is not asymmetric, it's a symmetric traditional war. There is a force on the ground which is aimed at gaining control over territory. It's called Daesh, or the self-proclaimed or self-described Islamic State. Is certainly anti-Islamic, but as a public international law, it's an entity controlling the territory effectively, much more effectively than many legitimate governments. So now there is a war, and it's a war that involves 60 states belonging to the coalition that supports Iraq on one side and the Kurds, as well as indirectly, implicitly, quite astonishingly, even the Syrian regime that might have committed even worse atrocities than ISIS. But that's where we are. That's the paradox in which we are. So my question to the panel is, what is needed to take place, and I'm looking at Ken Roth, what is needed to take place for the United States, maybe even at the level of the Supreme Court or other authorities internationally, to end up these absolutely, not only partially unlawful, because not always we are in a context of armed conflict, that's questionable, but certainly self-defeating and counterproductive policy of killing enemies that should be brought to justice when they commit mass atrocity crimes.
Well, that was a long meandering into that. There's no, if you have somebody say, somebody like Assad, who clearly should be brought to justice, but if the United States chose to go to war with the Syrian military because of the atrocities it's committing, there's no human rights argument why they couldn't target the commander-in-chief. So, while I'd love to see Assad in the Hague, if the U.S. goes to war and shoots him, there's no human rights basis to object. Similarly, this is, even with drones, if you have an armed conflict, drones, ironically, are relatively human rights friendly weapons because they are precise. Drones hit what you aim at, and you can, they can hover, and they can, pick the most propitious moment to fire. They can make sure that the target is the person they think they're targeting. All of that is a way of minimizing collateral civilian casualties. So that's, all for the good. The problem with drones, first of all, is problems of intelligence, and we see over and over again in Yemen where they just shoot the wrong car that's going down the road, or they get somebody who is with people who they really shouldn't be killing along with him. And so there are intelligence problems, but there also is this legal problem, which is that they are shooting to kill in a situation that I don't think is an armed conflict with respect to the United States. So therefore, policing law enforcement rules should apply, and they don't have a credible case to be made that the person being targeted poses an imminent threat of life in the United States, even leaving aside the whole question of whether capture might be feasible. But they have just played games with this concept of imminence to the point that it doesn't mean what it's supposed to mean. And it's essentially, if this person is maybe a relatively senior person in Al-Qaeda in the Arabian Peninsula, by definition we're going to call this person as posing an imminent threat. And that's not what the word means. So they're not, war rules shouldn't be applicable in Yemen with respect to the United States at this stage. And they are not following the policing rules because they're applying this extremely elastic concept of imminence.
Since the panel is called Closing Guantanamo, What Will It Take? And we've kind of danced around answering that question, I thought I'd just ask it directly. And if each person on the panel, if they want to, could say, in a couple sentences, realistically, in the political environment that we're in now, what would it actually take and what would that look like?
All right, I'll give it a crack. You're going to. I'll push aside for a minute the political issues that Ken has appropriately raised. I think that's always going to be the case, and it's going to take leadership from either party, from whoever the president is at the time, because there's always something uncomfortable about bringing a war to conclusion. You're always going to involve some threats. I think that's honestly a much more minor issue than others here probably do. I think the real issue is, as I've kind of said, you need to end the armed conflict first. That should be the focus of attention. Figure out what that takes. And I hate to say it, and I want to be clear, because I've been kind of holding up drones as the demon that's worse than detention or something like that, don't make the mistake of thinking I'm somehow against drones as a weapon of war. It's a weapon like many others. It shouldn't surprise anyone that ranges continue to get longer and longer as society moves forward. A drone allows greater range and greater precision. It's a very useful weapon system in many ways, but it's also the danger is not because it's lethal. The danger is because we can be so distant from the effects of war and perhaps stay there a little bit too long. Perhaps constrain ourselves with rules that do sound an awful lot like law enforcement with imminence, or sound an awful lot like a mini war in itself. You said Bellum, the Caroline case, and we won't get into it right now, but there's where the concepts of imminence are coming in, and we're mixing whether our tactics of using a particular weapon system with when you can go to war, and I think that's the dangerous mix. We need to decide when the armed conflict is at an end, but until it is, we shouldn't be limiting ourselves, and I do believe by not capturing people, we're limiting ourselves. Go watch Zero Dark 30. Our special forces are very capable today, and they're absolutely capable of capturing a lot of people. Imagine telling someone in this New York City Police Department, take down whoever, this drug ring, by simply killing everyone who's dealing drugs without ever looking at their laptop computer, grabbing their cell phone, interrogating them, emptying their pockets, and being able to question them and figure out the network. Not an effective way to take down any kind of a network, not an effective way to fight a war. So I think we should be trying to end the war, but until we end the war, fight it.
By the way, let me just elaborate on the point Bill made about imminence, because you're absolutely right. Just to make life confusing, imminence has two different meanings in this context. It comes up, first of all, with respect to jus ad bellum, the question, when is a government justified in resorting to military force? And in that context, the question is, in the right to self-defense, which is one of the times when you're allowed to use armed force without going to the Security Council, it's well understood that you don't have to wait until you're attacked. You can respond to an imminent threat. And their imminence is understood relatively elastically. You don't have to wait till they're about to pull the trigger. You can actually jump in preemptively and protect yourself that way. And so there is sort of this tradition in that the question of whether you go to war or not that has an elastic use of imminence. Unfortunately, the same term is used with respect to policing standards. And the police officer on the street can shoot to kill if the person poses an imminent lethal threat and capture is impossible. But there, imminence means imminence. It means, you can't just shoot the guy because he's going to go rob the bank and is driving there. You can't shoot somebody who's planning a kidnapping. You can only shoot them really at that point where they've got the gun pointing to your head, or is it really an imminent threat? But what the US is doing is, because of this tradition of kind of elastic imminence with respect to whether you can go to war or not, they've taken that same elasticity and applied it to the policing standards, even though it's utterly inappropriate to do that.
On the closed Guantanamo question, so there are two ways to do it, and the main obstacle for both is politics, right? It is in the capacity of the president to withdraw from the conflict in Afghanistan, declare the conflict over for purposes of the United States. There will still be a war there in the region, and to release the Gitmo detainees, right? That's one way, politically extremely difficult. The second way is to bring them all to the United States. Well, transfer as many people off as possible, all the people who've been designated for transfer, get rid of the Yemenis, get rid of everyone designated for transfer, prosecute everyone you can, bring everyone to the United States. Then you've still got that indefinite detention law of war group, right? Hopefully it's smaller because you've transferred some and prosecuted some. You've still got that group. And then you've got the question, have you closed Guantanamo, right? And Ken says, I think quite reasonably, if you still got them, you haven't closed Guantanamo. Some people say you have, but you could release them too. And when the war's over, you have to, right? But doing any of those things before you're legally forced to because the war is over is politically extremely difficult.
Michael.
Michael Cooper, thanks, Jennifer. Ken, the question's targeted at you, if you don't mind. My drone question coming at you. And forgive me, it may be a little bit off point. It's sort of pulling back from the point, and it actually may be even sort of quasi-personal, if you don't mind. But I'm thinking back to September 11th, and I was working with you at Human Rights Watch at the time, I think just a couple doors down from your office. We evacuated the building and all sorts of things. But a week or so later, you gathered all of us into the conference room at Human Rights Watch, and you sat us down and said, we need to start thinking now about what this means for the human rights community. What kinds of abuses and violations can we anticipate, and how can we align ourselves and start to prepare ourselves for what's about to come? If it's possible for you personally to sort of project yourself back to that moment in time and consider what it was you were anticipating on that day and what we've actually seen in the almost decade and a half since then, and what's different from what you had anticipated then? What things have sort of surprised you, human rights issues that have come up that you completely could not have anticipated almost 15 years ago when we sat down? Thanks.
Yeah, I mean, there's been an imaginativeness to some of this legal pliability that has surprised me. I mean, we did anticipate the torture right out. I actually remember getting in big trouble because that November, in our annual dinner, I talked about the importance of avoiding torture, and lost a big donor in the process. But that's so we knew that was a fear, and we were a little naive in accepting some of the Bush administration was very careful about making representations that contained loopholes that we didn't even completely appreciate, in terms of talking about fully respecting the Constitution, but then not admitting how limited their understanding of that was. And similar to the ICCPR, I guess at that point, we obviously didn't anticipate drones. We were still kind of in the era of cruise missiles, which are clunky by comparison. I don't think we really anticipated Guantanamo. The idea that there would be, really this, a legal black hole. I think because that's what it's been, and it's become legalized somewhat over time. But it did start off as a black hole. And we certainly didn't anticipate the CIA dark sites, which we kind of discovered fairly early on. But it was, there was a severity, an extremeness to the response that, if I try to put myself back into that period, is surprising. I didn't think the Bush administration would just be so determined to rip up some of the most basic rules governing law enforcement or warfare.
Yeah, here in the front row.
It seems anomalous that with U.S.-Cuba relations warming up, that there doesn't seem to be pressure from Cuba to take Guantanamo elsewhere. It's an affront, of course, to national sovereignty as it exists. It was the product, as you know better than I, of an imperialist European nation cultivating the island and leaving it as a heritage. What do you see in terms of political issues between the two governments? Does it augur a close? Does it mean they've put it on the side and they agree not to discuss it? And you have the thrust of my question.
I mean, I think the Castro government has brought it up, but it's not going to be, they're not going to make it a kind of a sine qua non of better relations. There's too much else at stake. And so, they want to get as much of the embargo lifted as possible, and they're not going to let Guantanamo stand in the way. I mean, I'd love it if, the salvation for closing Guantanamo turned out to be Cuba, but I'm not going to hold my breath on that one,
Yeah, in the back.
Okay, my question goes for Bill. I'm sorry, Bill. Are the detainees in Guantanamo being treated psychologically in order to get a prognosis and to determine whether they are able to be put back into society or if they are still a threat to join Al-Qaeda or any other terrorist groups? And for Sarah, why do you think Guantanamo is kept so clandestine that the world doesn't know much? I think the world should know much about what goes on in Guantanamo.
With the question of treatment, yeah, I'm sure you've heard, it's a current theme for those trying to close Guantanamo, however it's being closed, including Sarah's way, and recognizing my answer was not including the move it into the United States answer, because I think that can be done without the war-ending piece. I just think there's less bang for the buck with respect to at least our allies that I'm familiar with who are bothered by Guantanamo. I think, like Ken, they would be in a position where they'd say, no, we're bothered by the fact that you're continuing to detain them. We don't care if they're in the Caribbean or in some place that's colder. And I can guarantee you they are much better off in Guantanamo than they would be in any U.S. prison facility. And I've visited a lot of them in looking into this question. Similarly, the treatment they're getting, yes, there is better medical care, psychiatric care, and they do avail themselves of it in very significant ways and in very significant numbers to a much greater degree than any U.S. incarceration facility you could imagine. They are treated, you just take all the best medical practices you could imagine, and that's what we use and did use, I'm assuming still use in Guantanamo, so they are being treated very well. And they're being looked at in terms of the problems they're going to have when they reintegrate in another society. I don't think that we allow those particular doctors to weigh in on whether they're going to be a recidivism, there's going to be a recidivism issue. I think you can figure, for lack of a better term, we're at the bottom of the barrel. The low-hanging fruit, if you will, there were 800 people at some point in Guantanamo, and we're down to 122. Nobody was an idiot and released the most dangerous ones right in the beginning. So you can figure, I would be of the opinion that the likelihood of recidivism is greater per person than they were at an earlier time, but we don't allow doctors to weigh in on that at all.
Is your question why aren't the Guantanamo facilities now more transparent? Is that your question? I mean, Bill may be better positioned to answer this than I am.
I was happy with you being
I mean, they're on a military base, right? And there are a lot of security restrictions to who can come to Guantanamo, and now the military commission proceedings are open, and press comes to those and so forth. Members of Congress, some members of the public can visit the various Guantanamo detention facilities except for Camp 7, which is the detention facility for the high-value detainees. But the military is still very nervous about security on the base in general and with respect to the detention facilities in particular. We had lengthy discussions when I was in the government about whether we could have family visits for the Guantanamo detainees, which would be one way to make the detention more humane. But that also raised complicated security issues. I thought they were surmountable, but others didn't.
Well, and just to jump on that, because I am familiar with it, one of the reasons is because of the concept of it being an armed conflict and an ongoing armed conflict. That's really the dividing line. When we talk, I mean, nobody would stop Ken Roth from coming down to visit Guantanamo. They would stop him from interviewing a detainee. And I think a lot of human rights groups don't want to really make that trip unless they have the ability to interview a detainee.
You know, I've gone to observe the military commission things, but I wouldn't go on a show tour of the detention center if I can't talk to people.
Well, and so there are plenty of tours. Certainly, I don't think we ever referred to them as show tours, but
that's what they are. If you can't talk to the people, they're show tours.
But you can talk to everyone but the detainees, and frankly, if you went to a prisoner of war camp in World War II, you'd have had the same thing. In fact, you wouldn't have gotten in to even talk to the guards, and you can talk to any guard down there, any doctor, the commander, and when those tours are given, they will simply identify anyone who's standing there and let them answer the questions of who's getting the tour. So it's not an issue of hiding what's down there. It's an issue of not allowing a voice for someone with whom we're at war. That's really the issue. The International Committee of the Red Cross, however, sees every single detainee and talks to every single detainee with the understanding that they operate under that's their job to be confidential and to not favor one side or another in an armed conflict. So everyone in the United States that's ever captured in an armed conflict, they have access, the ICRC has access to them. And I think that's an important thing for everyone to realize. That's been the case for years.
Well, I see there are still additional hands, but we're kind of over our allotted time. I think we'll bring it to a close. There is a little reception in the back, and perhaps the panelists can hang around for a bit and take a few more individual questions. Thank you very much to the audience and to the panelists for their fascinating remarks.